The best evidence rule requires that the content of a writing or other recording be proven with the recording itself, or an exact copy of it. Letting a witness explain the substance of the recording instead would risk allowing fraud or error to hinder the jury's role of finding the true facts. For the same reason, witnesses cannot generally testify to information they know only because someone else told it to them, whether orally, in writing, or some other way. The rule against hearsay ensures that the jury can observe, under both direct and cross-examination, the demeanor of the person who has first-hand information to convey. Without the rule against hearsay, cross-examination would be ineffective. The point of cross-examination is to expose any defects in the witness's honesty, memory, comprehension, or accuracy, as well as to reveal any biases that might have colored the testimony. That cannot be done if the witness does not show up. Allowing people to testify to secondhand information risks that the jury will be misled in 4 ways. First, there would be no way to test whether the person who actually witnessed the events remembered all the details correctly.
So, Mr. Tipton, how could it take you 5 minutes to cook your grits when it takes the entire grit-eating world 20 minutes?
I don't know. I'm a fast cook, I guess.
I'm sorry, I was all the way over here. I couldn't hear you. Did you say you're a fast cook? That's it?
Second, lies could not be as easily discovered by cross-examining a surrogate who may not even realize he was lied to, rather than the liar himself.
So, Mr. Crane, you could positively identify the defendants for a moment of 2 seconds, looking through this dirty window, this crud-covered screen, these trees with all these leaves on them, and I don't know how many bushes.
Looks like 5.
Don't forget this one and this one.
7 bushes.
7 bushes. So, what do you think? Is it possible you just saw 2 guys in a green convertible and not necessarily these 2 particular guys?
Well, I suppose.
I'm finished with this guy.
Third, there would be no way to test whether the person who witnessed the events was mistaken in her perception.
How many fingers am I holding up now? Oh. What do you think now, dear?
Thinking of getting thicker glasses.
Finally, the testifying witness may have misunderstood what he was told by the person who was actually there. The person may have said something ambiguous that was misinterpreted, or may simply have misspoken. If that person does not testify, there is no way to know. Barring hearsay ensures cross-examination, which reduces these risks. The common law defined hearsay as an out-of-court statement offered for the truth of the matter asserted. There are 3 elements to hearsay. First, there must be a statement. Second, it must have been made out of court. Third, it must be offered for the truth of what it asserts. Rule 801 defines a statement to be anything intended as an assertion. This includes not only oral and written statements, but also actions, gestures, codes, and symbols that communicate an assertion. The rule clarifies that out of court means not in the present proceeding. The jury deciding the present case must see the declarant testify, and the fact that the declarant may have testified before a different jury changes nothing. The declarant is the person who made the out-of-court assertion. It is important to distinguish between the declarant and the witness testifying in court about the declarant's out-of-court statement. However, it is also important to understand that the declarant and the witness can sometimes be the same person. For example, if a person who saw a car accident wrote down what she saw, that writing would be an out-of-court statement. That person would not be allowed to read that statement in court. She would be required to testify from her recollection of what she saw. The out-of-court statement would be hearsay, even though the witness was also the declarant. A statement is offered for its truth whenever its relevance to the case depends upon the statement being true. Some statements are relevant for reasons other than their content. For example, suppose the declarant's statement was, "It's cold in here." The statement might be needed to show that the room was air-conditioned or not heated in the winter, or that the declarant was not outside, or had a fever, or just felt cold. For any of those purposes, the statement would be hearsay, because it would only be relevant to those points if the declarant in fact felt cold inside. On the other hand, if the same statement were offered to explain why the declarant's husband went down to the basement to check the boiler, the statement would not be hearsay. In that case, it wouldn't matter whether the declarant was lying or just wrong about it being cold. The statement would still show why her husband went down to the basement, regardless of whether his wife was truly cold. Cross-examining the wife about whether she was really cold wouldn't help. This is called showing the effect on the listener. Similarly, warnings are relevant to show the recipient was put on notice and assumed a risk. It doesn't matter whether the danger was real or imagined. It matters only that the person was warned. Another category of statements not offered for their truth are those used to show a person's state of mind. If the declarant yells at his wife, "I'm sick and tired of you complaining about the temperature," that statement would only be hearsay if it were offered to prove that the wife's complaining had indeed exhausted the declarant. However, if it were offered instead to show that the man was especially anxious and behaving unusually that day, it would be relevant regardless of its truth. It would then show the declarant's state of mind. Similarly, when a statement is offered because it is known to be a lie, it can show that the declarant was aware that he had something to hide, which also shows his state of mind. For hearsay purposes, the law divides all assertions into statements and acts. Every intended assertion, whether expressed in words or otherwise, is a statement, not an act. This includes documents and recordings of all sorts, charts and graphs, gestures and symbols. Flying a diver down flag from a boat is a statement, not an act, for hearsay purposes, because displaying the flag is intended to communicate that there are divers in the water near the boat. All conduct that is not intended to communicate any assertion is an act, not a statement. Giving someone a book as a gift is an act, not a statement, even though the book is full of words, because unlike a letter or a note, the book is not given to assert anything.
It was the best of times. It was the worst of times. Message, Spock?
None that I'm conscious of. Except, of course, happy birthday.
Many products, from shirts to cars, bear the manufacturer's wordmark or logo. Similarly, many people own things engraved with their name or initials. Those words and symbols could be interpreted as assertions of ownership or authorship, but that is a hyper-technical view of hearsay. The better view is that such words and symbols are just identifying markings, decorations, not assertions. For example, nothing is sold in Coca-Cola's patented contour bottle except Coca-Cola. The fact that the unique bottle identifies its contents does not make it an intended assertion. It is only a unique design. All logos and similar markings, including word marks, should likewise be considered non-assertive markings. Certain legal acts can only be accomplished with words. For example, a deed conveys property using words. A contract creates new legal duties and entitlements. Even lending a friend a few dollars requires words that have operative legal effect. Any words, whether communicated in writing or orally, that create, alter, or extinguish legal rights, duties, privileges, status, obligations, or benefits are verbal acts, not statements. Because they are not statements, words having legal effect are never hearsay. Pleading guilty, taking an oath, committing perjury, and getting married are all examples of verbal acts because the words used have legal effect.
Oh, Wesley, will you ever forgive me?
What hideous sin have you committed lately?
I got married. I didn't want to. It all happened so fast.
Never happened.
What?
Never happened.
But it did. I was there. This old man said man and wife.
Did you say I do?
Oh, no. Sort of skipped that part.
Then you're not married. You didn't say it. You didn't do it.
Whether an utterance counts as an intended assertion does not depend on what the declarant actually intended. There is no need to speculate about the declarant's actual thoughts, as the majority in Stoddard versus Maryland eventually held. What matters is what the proponent of the evidence claims the declarant intended. In other words, when analyzing hearsay, we are concerned with analyzing only the proponent's theory of admissibility. The concurrence in Stoddard agreed, explaining that if the jury has to assume that the assertion was intentional for the utterance to be relevant, then for purposes of the case, it is an intended utterance. The prosecutor's theory of relevance was that when Jasmine said, "Is Eric going to get me?" she actually meant, "I saw Eric kill Kaylin, and I'm afraid he's going to kill me too." That interpretation is what makes the utterance relevant. If Jasmine meant anything else by, "Is Eric going to get me?" then her statement would be irrelevant because it wouldn't help prove or disprove any material fact in the case. This implies a crucial fact about hearsay. Whether an utterance is hearsay never depends on the phrasing or the form the declarant chose to use. There are innumerable ways to express the idea that Eric killed Kaylin, including nonverbal ones, and whether that assertion is hearsay never depends on which way the declarant picked to make her point. Again, the only thing that matters for determining whether an utterance is a statement is whether the proponent claims that the declarant intended to assert something.